Hey guys, and welcome to the Weekly Docket. Hey guys, good morning. Let me go back on the slides here. I was going through them a minute ago to see what's on them because I've been pasting them in as things have been happening. So not a lot of practice on this one. Let's see what's going on. Let's start with the Murdaugh case down in South Carolina. Of course, as typical, I would generally interrupt whatever important thing is going on to shout out to wherever you're from. So hello to Los Angeles, City of Angels, and probably some other things. And Ventura, California. Awesome. And Texas. Morning to Marsha Lynn. All right. So, man, look at this. Creepy clown sightings cause frenzy as police investigate reports in South Carolina. What could it be? Could it be the judicial branch? I think it might be some problems going on. Let's knock a few more of these out. Kentucky, an interesting state. I know a guy said he had a horse in his trailer there, and we came back. He saw somebody had broken into it, and now there were 2 horses in it. Oklahoma. All right. Yeah, some Western stuff. You guys are making me jealous. All right, let's get back into this disaster that's unfolding in South Carolina with lawyers murdering people, or not, depending on how you see this case. Unless, of course, Tiny Ninjas might be licensed attorneys as well. So I put this poll out here just to test the waters a little bit, saying that if the court finds that a court official was talking to the jury and telling them to ignore one side of the case, should you throw out the verdict? And 92% of the people said yes, and 8% of the people said no. I don't think there's ever anything that's going to be 100% when it's a poll, but this one seems like there's broad consensus that you shouldn't do that, and it violates the fair process of a trial, which I happen to agree with. So I'm glad to see the numbers that high. Now, we're going to walk through this, and when I get done with the Murdaugh stuff that I know about before we get into Kohberger, I'm going to go over a little bit of evidence stuff because I see a lot of interesting things there being said about what's what. So let's talk about the juror affidavits. There are kind of, I think, 4 jurors that are being relied upon by Murdaugh's team to ask for this retrial, right? And we'll talk about the process a little bit too. It's unnecessarily confusing. You don't really have to understand it that well. But anyway, they've got 2 juror affidavits, and I've got up here double hearsay. What? There's hearsay, there's double hearsay, there's triple hearsay. And generally speaking, if you want to admit something that's double hearsay, then the first hearsay has to have an exception, and then the embedded hearsay has to have an exception. So that's a little wild, but I'm not going to taint the discussion of the Murdaugh case with it. We'll hit that when we get to the end. All right, but see, okay, let me go back to this. So the jurors in this situation are saying, which I think is there are a lot of allegations, and some of them may be true, some of them may not. Some of them matter, and some of them may not, right? There's bad judgment, and then there are things that are, you cross the line. So they don't have to prove all these things, but if any of them that are material are true, this is trouble. So here we say, have juror 630 saying that the clerk instructed the jury to watch Murdaugh closely before he testified, look at his actions, look at his movements. And also not to be fooled by the evidence presented by Murdaugh's attorneys. And then the juror saying, I understood that he'd lie from that and that he was guilty. But even if you didn't understand that, the clerk has no business saying that. That's not to say the clerk did say it, but this juror has submitted an affidavit saying that the clerk said that. And then they also have juror 785, who was the egg juror, who also said, don't be fooled by the defense team. And then this affidavit is quite long because it gets into this whole Facebook thing and stuff like that, which I think is a little bit of a sideshow. I mean, if it's true, if they could prove the clerk fabricated all this stuff, obviously that's terrible. But if they can show that she told the jury to disregard the defense evidence, if they have credible evidence of that, that's enough. And the rest of it, the smoking and all that stuff, is a little bit beside the point. But still, they're trying to paint the entire picture here. But look at this. This juror 6. What did I do? Oh, I'm on the, I have it up there. I don't have it down here. I have a bigger picture down here so I can actually read it. So I'm going to have to click twice. I think that's what the issue is here. Got it. All right. But look at this juror 785 who said that the clerk said, "Don't be fooled by evidence presented to the jury by Mr. Murdaugh's attorneys." This is her recent affidavit. While she was still on the jury after Murdaugh testified, so in theory, the clerk made these statements about don't be fooled by Murdaugh before he testified. When the judge was talking to her about this Facebook thing and found out that the clerk talked to her without the judge, which that should not have happened, the court asked the juror directly, "So has she discussed the case with any of the jurors? Has the clerk discussed anything about the case with anyone on that jury?" And this juror says, "Not that I'm aware of." Isn't that contradictory to this affidavit unless they can further explain that by timing? So this is what I say when this thing is messy right from the start. And then, of course, the court also says at some point, "I'm not too pleased about the clerk interrogating a juror as opposed to coming to me and bringing it to me." Griffin says, "I was surprised to hear that." And the court says, "Yeah, well, everyone would be surprised to hear that. That is not the process." And look at this. We have good morning back to Seabrook Island, South Carolina. Life coach advice, because there's no legal advice on this channel. Don't get arrested and get involved in any of this stuff, because this is just enjoy the beach. This is pretty messy here. Huh? So to me, it's like, and this in-camera transcript is from Murdaugh's team. They submitted it as part of their package to the Court of Appeals. So that seems contradictory to me. All right. And this gets to this a little bit. I still don't understand how or why the jurors, when you say they, I think the jurors coming forward now when the judge gave each and every one of them every time they came back a talking to. Yeah, well, I don't know either. They'd have to speak to that. But the fact is that two of them have done it. Two of them have sworn to the court that the clerk told them to disregard one side of the case. That's a problem. It doesn't mean it's true, but that's going to be an issue. All right. Triple hearsay. Let me get down here. I want to make sure I can read it. It's kind of small on my screen. It might be small on yours. Now, here we have not only somebody out of court telling you what somebody else said out of court, but you've got a paralegal saying this, who's out of court, saying this juror told me this other person said this. So this REO Speedwagon triple hearsay, heard it from a friend who heard it from a friend who heard it from another, that the clerk said don't listen to the defense. So now we're way off into triple hearsay territory, and that can be an issue as well. But one of these jurors, I think, said she said the images would be disturbing. Again, she shouldn't comment on that, but is that enough to be a disaster by itself? But this juror does say that the clerk was off talking to other jurors at different times. And then there's this stuff about the media and going into the bathroom to talk about things. None of that's anything that I've ever seen happen. Not that I've done as many trials as a lot of these guys did, because I was in-house for a long time, but I've done them. And like Poot, I haven't seen this before or heard of it before. So this is not good. And let's get to the next one here. So we have two affidavits from jurors and two affidavits from a paralegal who spoke to a juror. So what is this? What are we dealing with? The issue is whether the Court of Appeals should suspend the appeal and allow a motion for new trial to be filed. And if that happens, and I think it probably will, then there should be an evidentiary hearing where a judge will look at this, and maybe the same judge, maybe not. Poot seemed to think the judge would be a witness here. I don't know how that's going to happen. But anyway, if this warrants it, the judge would have an evidentiary hearing. And in that case, bring the clerk in, I would think, and also the jurors, and say, what the hell happened? As I said before, not every allegation in all of this amounts to a violation of due process, and they don't have to prove all of them. You really need to look at the importance of each individual one as well as the context of the whole thing, I think. And when you have two jurors who say this under oath, I think you need to look into this. Now, looking into it might be that there's nothing to it. We'll have to see what happens with that. I think, to me, the critical allegation is don't be fooled by the defense. That's in the trial. That's basically telling the jury, don't pay attention to the defense. There are more than one juror saying that they heard this. So to me, that puts this one front and center. But there are other things said, too, that could be significant, like how will you vote? You shouldn't be doing that. This shouldn't take you long. the kick to juror, whether the clerk orchestrated that or not, the private conversations with jurors in the bathrooms and stuff, the egg juror conversations about how will you vote, how's your husband, what do you think makes him guilty, and then, you know, other things that were in her book, like we looked at each other and we all knew he was guilty and stuff. Now, I will say this. I watched a couple of videos with this clerk because she did some media tours for her book, and she said, I never talked to the jury about anything to do with the case. I wouldn't do that. So, of course, she was aware of that obligation. And secondly, she has said that she didn't do that. And, in fact, when the judge asked the juror before she was kicked out, has the clerk talked to you or anybody that you know of about this case? The juror said, not that I'm aware of. And now this juror puts this affidavit in play. So what is going on here? All right, before I read this, which is the case law cited by the defense, and I think it's going to be important. Let me stop to give a couple of shout outs here. I appreciate this super sticker. Internet isn't free, and thank you. Plus, it just validates that some people at least find this helpful, so thanks. And then also to members showing up and signing up here, I appreciate that. Of course, you can find the special member streams and the secret unlocking of free stickers. Who doesn't like free stuff? All right. Now let's get back over to the stuff here. All right. This is State versus Cameron. This was cited in the defense's brief, and I went and looked at it because you got to go read the source documents. So you shouldn't take anybody's word for what they say, including mine. But that's also why when I can, I try and show the pictures of it so you can see what I'm reading from. So the first block of this, let's take a look at, is how the court says the law is in a case like this. And this was an older case. There was a private communication of the court official to members of the jury, an occurrence which cannot be tolerated if the sanctity of the jury system is to be maintained. When there has been such a communication, a new trial must be granted unless it clearly appears that the subject matter of the communication was harmless and could not have affected the verdict. Did you like lunch today? How was that storm last night? So let's angle this in a little bit and see, well, what happened in this case that the court said you crossed over that line and we're throwing this verdict out, and then see how that compares to the allegations in this case. So in the Cameron case, the forelady knocked on the door of the jury room. The bailiff knocked back and asked the bailiff, said the jury wanted a description about if they went with a sentence of mercy, that he wouldn't make it life, the judge. And I told her, if you want to ask the judge anything, I will hand it to the judge. And that's a good statement. And I'll take a note for the judge. That's a good statement. I said it was impossible right at that minute, but I'd be glad to bring the message back. And listen to this, okay? And I said, this is a fair judge. That's all I can answer you. He is a fair judge. But I will take you back into the courtroom if you want to ask or give me a note, and I'll take it back to the judge. And they threw the verdict out. They threw the verdict out on the basis of those comments about the judge. So if the bailiff telling the jury, hey, he's a fair judge, don't worry about it, or whatever, is enough to throw a case out, then if the defense can show some of these comments made by the clerk were made, then how do you not have this verdict thrown out? So that's why I think this is so material. And obviously people that think that Murdaugh is innocent or that there wasn't substantial evidence of his guilt, they're going to support this. But I think he did do it. But I also think you can't have this stuff. That's why they have rules like this. And you can't have trials where people are talking to the jury about evidence and stuff in the middle of the trial. You can't be doing that. Court officials, particularly, that makes it especially egregious. And seeing a member here. Awesome. This must be a special Friday. Now, about the book, some people were like, well, did she rat herself out in the book? I haven't read her book, and I don't intend to buy it. I've looked at only a few excerpts out of it. I'm sure she didn't say in the book, I told the jury to ignore the other side. I framed one of the jurors. Those aren't the things that she said in it. Now, she did say things that I think are at least bad judgment, and I'll probably also support what the defense is saying, like they all looked at each other's eyes and knew he was guilty and stuff. Did you need to put that in the book? Did you need to write this book? Now, she did seek an ethics opinion before writing it, but the description of the book she was going to write to me seemed more like it was a book about how trials work and maybe touch on some famous cases. And that doesn't appear to be what this book was. But let's look at this and see if you think this is a good idea for a court official to be doing during a trial. Now, here she's talking about a reporter at the Wall Street Journal that they had birthdays around the same time. How about that? That's super fantastic. It was decided, some passive voice there. Where's the editor? It was decided to have a party for both of us at her Airbnb on the night of her birthday. And she invited many of her colleagues, so other reporters, right? And here's the clerk with a bunch of reporters at a party. They were covering the trial for regional and national media. There was food, birthday cake, a lot of laughs, and a little truth serum in the form of liquid refreshments. I think that's the Baptist way of saying alcohol. As we were cleaning up after the party, a few of us were asked how we would vote at that point in the trial if we were members of the jury. Before answering, we pledged a cone of silence. So that's great. So you had the clerk of court with reporters talking about whether this guy's guilty or not, while also participating and officiating in the trial, but having a secret cone of silence with reporters. And still will not reveal the results of this straw jury poll, but of course will tell you all these other things about how the trial went. Many of the party guests agreed with what ended up becoming the actual verdict of the trial. Is this appropriate behavior by a court official? So in terms of the ratting out or whatever, yeah, I don't think that's good. And here's a comment saying, Court TV mentioned that the clerk court accompanying 2 jurors to New York. She did mention that in her book, and how they got to ride in the SUV and go up in a tall building, and it was her first airplane ride, and they fancy meal and all that stuff. I think, no. This, I mean, if you retire and you want to tell how a case went, maybe you should, maybe you shouldn't, but that's okay. But you're the sitting clerk of court. Even if she hadn't said disregard one side's evidence, I would think this is not good. But it can also be worse than bad judgment. And here, let me get this bigger picture, because you may have seen this, but on the other hand, maybe you haven't. On the right side is a memorandum she issued to a company that was doing a documentary there. And it talks about, she's the clerk court, and it's talking about she wants to modify certain arrangements in the contract. So she's acting in her official capacity here, and I think she wants to upcharge and other things like this. But look at this little thing she puts down at the bottom. In exchange for the use of likeness of Rebecca Hill as the clerk in an interview, a minimum of a 5-second video and audio clip will accompany the usage on the first reference. The book cover for the book, her book, Behind the Doors of Justice, The Murdaugh Murders, will be shown, and audio will include Becky's introduction as clerk of court for Colleton County and author of the book. So here you have a court official, elected official, talking about terms of a contract that she wants to modify, and including this addendum here about the special arrangements to pimp out her book. She has lawyers now, and as a life coach, I think at this stage that's probably a pretty good idea to do it. I mean, anybody thinking this is okay? This is what we want happening in the justice system? I don't think so. Now, this is a comment I'm going to bring up here, not to try and dunk on you, but to address it. The defense team is grasping at straws to have an appeal. I don't agree with that for this standpoint. This stuff right here about seeking personal gain in an amendment to a contract, that's wrong. And to me, it does demonstrate there's some bad judgment going on here. Some really bad judgment, and it links over to some of this other stuff. But, you know, I did show where I think a juror maybe contradicted themselves and stuff. But here's an interesting issue. That Murdaugh paid off the jurors for their statements. If you have jurors who would take a little money to not only let a guy who they decided was guilty get a new trial, but also frame a clerk of court for potentially criminal activity, are we supposed to trust their verdict in the first place? I also won't agree that they've been paid off or anything unless there's evidence of that, because there is less evidence that the jurors were paid off to make these statements than there is that the clerk made the statement. So if you're talking about an evidence stack, I don't see it. But having said that, if there is and remember, this isn't does he get a new trial? This is there an evidentiary hearing for a new trial? And if other jurors come forward and say, this stuff never happened, this didn't happen, one of the 2 jurors who commented directly said the exact different thing to the judge, we don't know how the one remaining juror will go, then a judge could say, look, she didn't do this, right? But I'm not saying she did do it. I am saying that the issue at stake is whether they've shown enough that a judge ought to look at it, and maybe so, but that's just my opinion. Like I would not. There's no evidence the jurors took any money for anything, but there is evidence that the clerk was seeking these kind of benefits from a contract, and then there are 2 sworn affidavits that she made these statements. There's more evidence of that than there is anybody was bribed in this situation too. I also saw a comment, which I wasn't following the logic of, that the clerk may have been paid off earlier to do this stuff in order to give him this option to file for new trial. And I think it would be a very risky procedure to have a clerk tell the jury to find you guilty, and then nobody hears about it for months, and then also write a book saying you're guilty. Maybe you would want the clerk to try and help you be found not guilty, or just go ahead and pay the jurors up front if the jurors are all on the take and the jurors are criminals themselves, is what this would, if they're taking bribes to put affidavits in place now, then they're criminals, right? How could you trust their verdict in the first place? So I'm not going to assume they're criminals, but I'm not going to assume that what they're saying is accurate either. That's the point of having an evidentiary hearing. So it seems like a dumb idea to write a book about a trial of this magnitude. I wonder if somebody pushed her into this. I haven't heard that. I did hear her co-author. I think he was on Court TV talking about it, that she came to him and she did write for the ethics opinion. It seemed like something she wanted to do. And I can understand that. She's in an event that has a lot of public coverage, but you can't do that. You just do not do that. And the ethics opinion did point out to her the risk of doing it, even though I think she went beyond what she told them she was going to write the book about. And good morning to Judy, the internet lawyer, a Legal Focus. And if you haven't watched her video, I think toward the weekend there, of the comedy part that she put up where she simulates direct examination of Wendy Adelson, then you have missed out, my friends. You have truly missed out. That's a level of talent that I can admire but cannot aspire to. All right. Yes, the jurors were polled at the time of the verdict, and they said it was their verdict. Now, having said that, if the clerk had said to me, don't pay attention to him, I still might think that's my verdict, because I might be like, well, I wasn't going to pay attention to him because I already think he's a liar. And so I hear what you're saying there, and I don't disagree with your point. Like, how come nobody mentioned this? And other people have brought that point up, and I think it's a good one. And as a matter of fact, as I showed earlier, the judge asked a juror, has the clerk, not just has anybody in the abstract done it, has the clerk talked to you about this case or talked to anybody on the jury about the case? And that juror who submitted an affidavit now said no. So if you're skeptical of what the jurors are saying, I agree with that. I just wouldn't go as far as to say they're doing what they're doing because they're paid off or whatever. There are a lot of ways to massage affidavits without paying it. But look at there, Williamsburg, Virginia, Colonial Williamsburg. Yeah, I saw the triggering. This is Judy's comment again. It triggered somebody who thought it was inappropriate. There are a lot of super serial people out there that want to lecture you on how you should never have fun and all that. That's social media. There's always a nattering nabob of negativism out there to tell you how to live your life and to be disgruntled, constantly disgruntled. And I typically will yeet somebody like that, especially if the insults are lazy. All right, let's move this puppy forward a little bit. But I agree to be skeptical of the jurors. Let me go with that. I just wouldn't throw out an allegation that they accepted a payoff. I would agree with you that Murdaugh would offer one because he's absolutely crooked, and I think he committed the murders too. But he's certainly crooked. He certainly has no ethics. If he could have paid the jury to let him free, I think he absolutely would do it. I'm just stopping short of saying that I think these 2 affidavits that they did get are because of a payoff. But it's South Carolina, and it involves people. So you could be right and I could be wrong. So let's wait and see. Now, I have seen some criticism of the judge, and I wanted to comment only on a couple of those things, because if you didn't like his rulings on actus reus and how much he let in about financial crimes, and that did seem to be a lot, I get it. But I have seen some people say, well, he selected the 4-person. That's terrible. And this is straight off South Carolina Judicial Branch, telling people how juries are selected. The judge appoints one of the jurors to act as a foreman. I mean, sometimes the jury does that, right? So a lot of jury procedure depends on what jurisdiction you're in. And then within that jurisdiction, sometimes how the judge wants to do it. Look, for example, on note taking in South Carolina. The allowance or disallowance of the juror note taking during a trial rests with the sound discretion of the trial judge. So these, if you see these things and it happened like this here, but it happens a different way somewhere else, that doesn't mean that the judge was doing something crooked or whatever. But if you disagree with his rulings, I hear you on that. Do I think this stinks of corruption? Oh yeah. Yeah. Oh yeah. This is really messy. And while I think it warrants the evidentiary hearing, I can't tell you what I think the hell is going to happen in that evidentiary hearing. Who knows who's going to say what? And if you've been watching this, because I don't have the slides for it, you've seen lawyers stepping in to represent the jurors. And you may feel that some of those lawyers are aligned on one side of the case or the other, philosophically or potentially procedurally. It's messy. It's beyond messy. It's not a good look. And I know that South Carolina law enforcement says they're looking into it, but I would think if they care about the reputation of the judicial system there at all, they have some real work to do to clean this up. It's not good. I mean, if you're going to have any confidence in what they're doing down there, how can you? And a lot of people, of course, thought, well, Murdaugh is obviously a crook, but they thought the way they're prosecuting him was also crooked, that there were lies, mistruths by law enforcement, slip-ups, cover-ups, stuff like that. And some of that has validity to it. So it's a disaster. That's for sure. Yeah, I heard the Putin a little bit of that. It was his Mercedes, man, may have some dust on it. And they travel to places in the county he didn't know existed. Dirt roads. That is weird. I don't know why he said that. Maybe he was pitching to the audience there. There are fewer dirt roads than there used to be. I mean, when I grew up, a lot of roads were dirt roads, but not so much anymore. I'm in the metropolitan area near Raleigh. I can see downtown from where I live. I just don't have to be in it. So let's step this forward. And I hope Judy will still be listening, because I'm going to mention some cases that I know she had involvement in at least one. And she may be able to correct me if I make an error, which she does, and does politely. All right. I put this up a little while ago. At trial, a party asked the court to admit an affidavit of a person who has personal knowledge of a fact at issue at trial. The affidavit is properly sworn, properly witnessed, and contains statements only of facts which a person... Now, you ought to know that if I'm writing all this stuff about how correct this thing is, I'm trying to trick you into thinking it's correct, because the answer is there's some reason why it's not okay. And pretty much you split down the middle. The idea is, can you just throw up an affidavit as evidence in court? And a general answer is no, because it's hearsay. It's hearsay. Now, they can be used for motions and stuff, and also sometimes at court, in trial. But let's talk about why this is. She is there, but she's going to Busch Gardens. Well, that ought to be fun. My brother basically lives there with his kids. I think he can vote at Busch Gardens, maybe. If he's listening to this, he can confirm it. He may be there too right now. So if he gets in trouble, look out for him. All right. What is hearsay, people? So here's our deviation before we get into Kohberger, just to talk about a few things that I've been seeing mentioned in the media, at least as I understand the law. And don't sit at the top of the Supreme Court. So, you're getting what you're paying for here. What is hearsay? Hearsay is a statement other than one made by the declarant. That's the person making the statement. It's a statement made that's not while testifying at the trial or hearing, and it's offered in evidence to prove the truth of the matter asserted. Now, the big loophole you would normally try to use is, I'm not offering it to prove the truth of the matter asserted, because then it just doesn't meet the definition of hearsay. But in my hypothetical about the affidavit, it's a statement made outside the trial, right? Not while testifying at trial, and it is being offered to prove the truth of the matter asserted, the fact at issue in trial. So it's hearsay. So hearsay is generally not allowed unless it comes under some exception, and there are a lot of exceptions. Look at that, man. I'm sorry. I have this stuff too small and I didn't move it up. So there it is, so you can see what I just read. And while you're looking at that, if Murdaugh's granted a new trial, found innocent, well, he would be not found not guilty, of course. And I don't mean to pick on you there, but all they have to do is fail to meet their burden of proof. So the jury's only asking, is it guilty or not guilty? That, the defendant will come out saying they're innocent, but all that really happened there, and they might be, is that the jury found the state didn't meet their burden of proof. But anyway, the main point of the question is, will he spend the rest of his life in prison? Yeah, I think that's a given. All right. So now that I've weighted that one out so you can see what I was reading a few minutes ago. So affidavits are generally hearsay. Okay. Now they might be used for various purposes, motion, summary judgment, to support a motion for new trial like you have here. They could be stipulated to by the parties. And there are certain rules that allow affidavits in certain kind of contexts, maybe to admit business records and some other things. There are certain kinds of cases where they maybe could be used more, but generally the idea of evidence is, by statements of people, is they come into court and they make their testimony, but there are a lot of exceptions. And this one's going to matter here too, because I've seen some comments about that. What about prior testimony in court? Well, that's generally hearsay too, because you're not testifying at the trial or hearing, right? So it's a prior hearing, so it's going to be hearsay. Now, you might be able to use it for impeachment, and that happens a lot. There are also cases where the declarant's unavailable and certain conditions are met. So maybe the person who did the testimony died, and it was a case involving you over the same issue. Maybe this is a retrial or something like that, and you had a chance to cross-examine, and you meet all these conditions. Then sometimes if the declarant is unavailable, then the prior testimony might be able to come in anyway. It's an exception. A party opponent. So if you're offering a hearsay statement by the person you're in the suit against, that can come in. And that one matters a lot too, because the party opponent in a criminal case is who? The defendant. You do see a lot of cases, I'm sure everybody has seen, where they show the interrogation video, the statements the person made to the police when the police arrived at the scene, statements that they told another witness. So they call up somebody's cousin or something. He told me he put the gun in the lake. He told me he had to kill that dude. Well, that's hearsay, but it's coming in because that's a party opponent. So let's look at this. Testimony by a former testimony by a witness. And maybe I covered that good enough, but this is from a North Carolina resource here. If the declarant is unavailable, testimony given by the declarant as witness in another hearing is not barred by hearsay rules as long as the party against whom the testimony is now being offered had an opportunity and similar motive to confront the testimony at the prior hearing. In criminal trials, former testimony is admissible against the defendant only if the defendant was present at the prior hearing and had counsel or waived a right to be there. So I think the case that I had with the woman who left a letter, and we did all that we watched that together. They showed some stuff on videotape from a prior trial because some of the people had died. But this is the kind of rule that they have that allows that. What about a party's own statement? A party's own statement is a classic example of an admission. And this was a criminal case here. Parties' own admissions are admissible as hearsay exception. The declarant can't be heard to complain about not having a right to cross-examine himself. So if a defendant, therefore, in a criminal case, talks to the police at the scene or in an interrogation or to friends or to a jailhouse snitch or whatever, you'll hear that testimony being given, even though the defendant's not testifying, so it's not impeachment or something, because it's an admission by a party opponent. And this is going to matter a lot, because I've heard people saying, well, what about Murdaugh's prior testimony? What if he doesn't want to testify? And I even heard some lawyers on TV saying, oh, well, they can use it to impeach him. Well, of course, if he doesn't testify, you can't impeach him. But in many jurisdictions, they'd just be able to use it anyway because it's an admission by a party opponent. At least some of his statements were. But South Carolina, as you may have figured out, is in its own way special. And they have a special statute. And I'm still doing it. I'm looking at the wrong slides. Here's their special statute. Testimony of a defendant in a criminal case. The testimony of a defendant in a criminal case shall not be afterwards used against the defendant in any other criminal case except upon an indictment for perjury. So what does that mean? Do you see in there, unless you feel like impeaching him? So what is the other criminal case? Is a retrial, or after a mistrial, a retrial occurs, is that an other criminal case, the same case? There's going to be some briefing on this issue because South Carolina makes this special exception that you can't use this prior testimony, it says, right? Prior testimony in a future case, in a other case. So that doesn't exist everywhere. And it might protect Murdaugh. It's why I thought that he was willing to admit to these financial crimes in his trial, knowing that they have this weirdo statute. So if he did go to trial on financial crimes, he could block that testimony from being used against him. But I don't think it ended up mattering. But I saw this and thought, well, maybe that's why he's doing it. But let's bring it back closer to home here with some cases that occurred near here. So on the left side, you have Michelle Young, who was murdered by her husband, Jason Young. And that was a terrible case where he called her sister, who was somebody I knew slightly, and asked her to go check on something he left on the fax machine because he didn't want Michelle to see this present he was going to get. And when the sister gets there, she finds her sister dead and their young daughter wandering around with blood all over. A horrible scene. So he finally goes to trial, and I was a nerd enough in his case. I actually drove his route from the hotel he was staying at because I was coming back from Kentucky to see if he could do it in the time that the prosecution said, because I had to drive home anyway. And this was all just down the street. So he goes to trial, and in his first trial, he testifies, and that was, I think, kind of a surprise. Told all kinds of lies and stuff like that. And I think to be fair, he caught the prosecution a little bit flat-footed, and it was disturbing to watch it because I certainly believed he was guilty. But the jury hung, so he got a mistrial, and he went to trial again. Well, guess what he didn't do in the second trial? Take the stand. Guess what they did do in the second trial? Showed videotape of him lying his butt off, and how the facts showed that in the second trial. So his first testimony was a big gamble to try and get him out on a not guilty verdict. And it didn't work because some of the jurors hung on it. And then it came back to haunt him in the second trial when they were able to prepare for what he had already said. And he didn't try to explain it in the second trial. So he's right where he needs to be, which is in prison. On the bottom right is a tougher case. And this is Brad Cooper down there with Nancy Cooper. And they lived over in Cary, not far from here. And the connection I had to that case was, this was years ago. I used to do a lot of triathlons. I did one with this guy. Well, the jury found that he was the person who strangled his wife in their home and had dumped her down the road down here, where somebody who went for a walk found her. He was sued civilly, and some of those deposition excerpts were used in the criminal case against him. He didn't testify. And while I think they got the right verdict, his lawyers, who I'm pretty sure Judy knows one of them well, and maybe even does some streams with one, said, look, he didn't kill anybody or didn't kill her. That wasn't my opinion on it, and there's no attorney in the case. I was just a watcher of it. He ended up pleading guilty after I think he got a successful appeal because the judge erred in restricting some of the testimony in the first case on some of the experts, which I thought was kind of iffy too. Didn't let their computer expert talk about how some of these map tiles got in the case and stuff like that. It's very technical. And so I think he ended up taking a plea offer after that. But that's a terrible case. Both of those, they were married, and the domestic disputes arose. The first one, I think, was highly premeditated. The second one, to me, seemed more of a crime of passion and just a devastating situation because there were kids involved in all of these. But the point here is that prior testimony was used in the trials against these guys, even though they didn't take the stand. So sometimes I've heard, well, you can't do that, but it has been done in these cases. And Judy said she wasn't working with these guys when the Cooper case is going on, but I think she does know them. And they did a good job. I still thought Brad was guilty, but I thought their defense was good. But to some degree, they were trying to say that this map search where I think he zoomed in on a particular tile where they were building this neighborhood maybe had been planted there. And they were losing me a little bit on that one without some evidence. But anyway, the case resolved with a guilty verdict. And the kids, I think, are with the grandparents and maybe her twin sister or something like that. So just terrible situation there. But anyway, I thought it was interesting that people understand that, like, you're at the police car and you're talking to the police, and that comes in against you, and you're into the interrogation thing, and that comes in against you. You're talking to your friends, and that comes in against you, but your prior testimony in court can't come in against you. But in South Carolina, that can be true because of that weirdo statute that they have down there. It's weirder than I thought. Yeah, I thought Brad was guilty. Who else would want to kill his wife? Judy says, yeah, and I used to do a lot of cycling down through that area of Cary there, over near Lockmere, and you'd see the flyers up and stuff like that before she was found. And then there was a rumor somebody was attacked in a van at this other park nearby, and so then we were all watching out for a van in the early morning, and because we'd exercise super early in the morning, so we were watching for this stuff because she was allegedly out jogging when she was attacked. Of course, that turned out the jury concluded that was untrue, and that worked out for the best, I think, because it's better than some person roaming around. But in both of these cases, it turned out to be not tiny ninjas or van driving ninjas, but unfortunately, the two often true story of domestic disputes that rise to the level of death until death do we part being the loophole instead of the commitment. All right, let's get out west, okay, and out of the humid confines of North Carolina into the clean air out west and talk about Bryan Kohberger, the camera fight developing. I recycled that joke. But here we see that the defense says we'll have this motion on the 13th. So his attorneys have moved to remove cameras from the courtroom. In somewhat of an irony, the judge has signed an order saying, okay, and we will cover this hearing with cameras. But like he's been doing it, there's no broadcast option. You see, that's denied, but the ability to take pictures and take video is allowed. So whatever they do in there will come out, although I think some of these hearings are mostly, the audio you get is the typing of the clerk, and it's hard to see and hear what's going on. So, but here's an interesting thing here. The state has given its opinion on this, and they say that witnesses are being threatened, witnesses are being harassed. There'll be a chilling effect on witnesses if there are cameras in a courtroom. It's a threat to fair trial for all sides. And that's what they say in their brief. They talk about the surviving roommates, other vulnerable people, and they've been harassed and threatened, and their families too. It says the state fully understands the enormous value that responsible media has in helping the public to understand the true facts of what occurs in court. The state believes, however, that those ends can be accomplished without the need for camera video images or the physical presence of cameras in a courtroom. So they don't want the cameras in there either. So you have the defense saying, we don't want cameras. You have the state saying, we don't want cameras. It's the judge's job to balance the right of the public to know what's going on, and the media has intervened in this with the desire of the parties. But what the prosecution is suggesting is, hey, take a look at that Vallow case where the judge allowed these audio recordings, and the case, which was also a circus, managed to go off without it being a complete and total disaster. So I think they're offering that as a compromise solution. So I don't know what the judge will do here. This judge has been a very balanced person. I think he's certainly going to think about it carefully. And right now, you know, there aren't great cameras in there, but he has been allowing some coverage of it. But I think they're more worried about what happens when we start getting witnesses in here and stuff. Okay. Now, they also have filed some additional documents on this internet, or this family genealogy stuff. You know, they used a certain profile that they found off the sheet to locate his family, right, in these databases. Well, there was another court there addressing it, and the state said, well, when we get that result, we'll let you know. I don't think it's binding because I think it's a sister trial court. That's why I put that on here. And but still, it can be instructive on how to handle this, because this stuff is still somewhat new in the law. And that judge basically said, this is from the defense brief, what I've got on the screen right now, that the judge said that, yeah, they should be able to get this stuff. But it was kind of a middle ground. And here's actually from the transcript. So the DA tells the judge, I want to note for the record, again, for the sake of transparency and candor to defense, that we don't have a report in our possession, and we wouldn't be able to get one if we tried. I think that's talking about from the FBI. If we were ever able to obtain anything from the FBI, for example, of course, we would disclose it, but the chance of that occurring appears to be zero. So the court said right now the ruling is that the state doesn't have to disclose any genealogical database not in its possession. And what the court basically said is, you know, if they don't have it, you can't make them turn it over, but you can subpoena other parties potentially. And also there's no report to disclose either. Well, clearly under Rule 16, if he doesn't have a report, how is he going to disclose it? So, I mean, that's already not covered by this rule. This is the judge talking. I feel like you're going to see something similar from the judge in this case, because while I don't think this family tree stuff is going to matter at the trial because the state says it's not going to use it anyway, I do agree that the defense should have a lot of latitude in its discovery to get information. And that seems to be what this judge has said. And I think it's probably going to be what judge says as well. So I hear Sarah Boone's hearing has occurred. Well, of course, reading her letters yesterday, she concurred with the lawyer getting out of the case. So I can't imagine how that doesn't happen. And then where we go from there was, I assume somebody gets stuck on that case, which is bad news for them. But I don't have it in front of me. And but the court just let tiny ninjas do their jobs. It appears they're not being restricted by the court very much because they keep doing all these various crimes in different states and stuff. So anyway, this was a lot for these two cases. So we have the Sarah Boone news coming out whenever that comes out. Sorry, we don't have it. That was scheduled for 9 this morning. And then Darrell Brooks has his counsel update. I think that is next week. So I'll try and cover that. And I've seen nothing put into the record so far of anybody being appointed. So this still points to he'll wait till the last second and perhaps say, I'll do it myself. Or maybe he'll try to get another lawyer and then fire that lawyer, or attempt to fire that lawyer on the eve of trial again. I don't know what he's going to do, but I think his hearing or status update is the 13th. And that is all of this stuff. So on the Murdaugh stuff, you know, I'm not swallowing what the defense is saying. All I'm saying is there's enough there with the sworn testimony of the jurors that somebody needs to look at it. And what the result of that looking at will be, I don't know. I assume the clerk's going to say, like she said in her live interviews, I didn't talk to the jury about anything to do with the case. I didn't say don't listen to these people. So that's probably what she'll say. And maybe the other jurors will say that too. And, you know, if it's 10-2 or 9-3 or whatever, the judge has some decisions to make. But I think the point is, should they have an evidentiary hearing now, not have they proven that this was fraud or whatever? That's not even the burden at this point. And I think they met that, unfortunately. But, I mean, the rules are the rules. And when you have this level of testimony, they at least ought to look at it and say, hey, did this happen or whatever? And if money changed hands and they prove any of that, people need to go to jail. That's for sure. Who the hell knows what's going on down there? And I see somebody saying trial set for the 11th of December, but I don't know. Maybe that's talking about Boone. Not sure. So yeah, I'll look it up and I will make a comment about it if I see it or something like that, just to follow up from her letters from yesterday, which were better than a cup of coffee in terms of wiring you up if you have to read them and channel what she was saying. Yes, Boone. Okay, well, thanks for that. So we'll see. I don't know if you know whether they appointed another attorney or what they did beyond setting the trial, or somehow shockingly kept the same attorney. Wait, no, okay. We do have the answer here. Shell, thank you. Winston Hobson is the new lawyer. He drew the short straw. So I don't know if he went through the vetting process that Sarah Boone demanded of the judge yesterday in her letters that we saw. Good luck to Winston Hobson. It's kind of a cool name, so we got that going for him. If it appears in letters and things, it'll be fun to read that. Hopefully, though, the case will get streamlined and actually move on to trial and get resolved. But at any rate, I think we all can give our best wishes to Winston, and hopefully he won't try and talk to that stale, nasty old psychologist, because remember, Sarah wants a brand new one. She needs all new experts. Yes, did the judge throw a dart? She did tell the judge he needed to start aiming better. And as Winston Hobson, it's his nickname, the Bullseye. Will it live up to that name? These are all things we don't know yet, but that's what Sarah demands. She's only asking that the system give her the very best of all of them. And she's been startled at the flaws in administration of justice that she's observed in her time and being incarcerated. And I hope they, you know, if she were to somehow dodge this verdict, or maybe even if she doesn't, she could become a consultant to the court system to improve how they operate, because she clearly knows how to do all of it better. It's worth watching. The judge had words for her. Well, you know what? I thought they wouldn't show that, but I am going to have to watch it. I can't stand not watching it. So I will try and find that and check it out. Think of all the money wasted on Sarah Boone. It's been a lot, because like I say, when I pulled her whole docket and went back through all the experts that had been appointed, I was pretty surprised. They have definitely spent considerable money on her, and yet she doesn't even appreciate it, because she wants to not use recycled experts. She wants the fresh ones, and that may suggest to you that she didn't get the results from the early experts that she wished that she had gotten. You just got booned. Yeah, exactly. You guys have gotten that in my lexicon. There's no way that I'll make any further video about Sarah Boone and not have that coming out of the Boondocks here. So I'm going to go see if I can figure it out and find that and check it out. And if I do find it and I'm going to watch it, I might just throw it up in the stream real quick if I possibly can, because, I mean, why not? All right. Well, anyway, I'll be on Eric's show at noon. If anybody wants to stop by for that, we'll probably say something that makes people mad, because that's how that works. And it'll be a lot of fun anyway. It's definitely an interesting thing to do, and talk to a lot of other good lawyers on that. And that's it. And if I see you there, that'll be great. If not, have a good weekend, unless I see you on some Sarah Boone thing here in a few minutes. Thanks. Bye.